name is Lorena Columbi. I'm a visiting PhD student at the American University in Kosovo. Since almost a month, we've been engaging in organizing a weekly speaker series focused on issues of democratization and rule of law, touching upon sensitive questions related to the state of rule of law and democratization in Kosovo. We are proud to set up a group of experts and scholars doing research in Kosovo. Today, we started having, let's say, a weekly meeting and touching upon questions such as, for instance, constitutional design in Kosovo. We had Vjosa Osmani, a member of the Kosovo Assembly, having a presentation on forms of power sharing in Kosovo and constitutional design. Then we had Sandra Joyman, a Fulbright scholar, doing an introduction on property rights in Kosovo. And today Jason is having his presentation on reforms in the juvenile justice system in Kosovo. Jason, let me do a brief introduction. He's a lecturer at the American University in Kosovo. He's been teaching public speaking and also a course in nationalism studies, law, and diplomacy in former Yugoslavia. He has a JD from University of Oregon. He's been doing extensive legal research as part of the American Bar Association Rule of Law Initiative in Armenia. And he's also a co-founder of Youth Courts International, an initiative that is trying to promote measures of diversion for, let's say, dealing with juvenile offense and juvenile crimes. So basically, Jason is he's a Fulbright grant recipient, and he's doing his research on Kosovo juvenile justice system reform. He's been undertaking interviews with major stakeholders, prosecutors, and judges taking part in this process. So we're just looking forward to listen to your presentation and to your research results. So the floor is yours.
Thank you everyone today for braving the cold and the snow to come to a talk on juvenile justice. Usually not a topic that brings out a lot of people, so the fact that you're here with the snow is very impressive to me. So thank you very much for coming. So you have a little bit of an idea of who I am and why I'm here. The State Department was kind enough to give me a grant to show up in Kosovo and to research. Initially it was supposed to be about judicial reform and the new law of the courts. At least that's what I talked to the State Department about a year and a half ago. But it turns out when I showed up, judges didn't want to talk to a 28-year-old American recent graduate. So, with my interest in juvenile justice, I decided to twist my Fulbright research into focusing on a topic that people were more than happy to talk to me about. So most of what I have today is through both the statistics that I've been able to gather from the variety of different Ministry of Justice agencies, as well as interviews with the stakeholders, as Lori said, throughout Kosovo. The goals of this presentation, I feel, are threefold. First is that I want to talk about the research that I have thus far. I want to be able to get feedback from everyone here that might have some insight or input into this process, because this is really the first time I've spoken publicly about it. So I'm sure there's assumptions I have and poor translations that I've done that have left me in a confused state that you can correct me about. Secondly, this is a presentation that focuses on diversion in the justice system. So while I'll give cursory comments about the police, about the judges, about probation and incarceration, that is not the majority of this talk, nor is it where my research is mainly focused. A few shortcomings, so just so you know what you're getting into before it happens, is that at this point in time I've only been able to put together one one interview outside of Pristina, and that was in Jalan. Hopefully in the next few weeks I'll be headed to Prizren and Peja, and I'll begin to shore up that problem. Translation, of course, is always an issue. My one semester of Albanian at Alliance Française does not get me to the point of discussing any form of justice with any person that speaks Albanian. So Lori has been kind enough to help me there. And then lastly, anyone who works with the justice system in Kosovo knows that the statistics here are very much cobbled together. There's a lack of standardization, there's a lack of centrality to them. So when I start talking about statistics, most of them have a big asterisk next to them, stating that I know that it might be wrong and it might not be 100% accurate, but it's what we've got for the time being. So with that in mind, What I hope to talk about today is generally why juvenile justice matters, not just to Kosovo, but internationally speaking. Then we're going to talk about Kosovo generally in regards to the process to juvenile justice. Then I'm going to dive into diversion itself, both the successes and the recommendations that I see thus far for Kosovo. And then at the end, I want to do a brief introduction to the idea of youth courts as a form of diversion, which is a peer-to-peer alternative, which essentially empowers minors, people under the age of 18, to take control of the diversion system. It's been very successful within the United States, and I think it's flexible enough to work in other countries and cultures. So that will be the last portion. So let's start off on why juvenile justice matters. These are a lot of different legal ordinances, UN treaties, conventions, courts that care about juvenile justice. I could bore you with talking about them. The thing that you really need to know is that the Convention on the Rights of the Child is the most important one. Every country in the world has ratified it except for Somalia, South Sudan, and the United States. South Sudan and Somalia are going to approve it soon, they say. The US will not. So outside of that, it has truly become the international standard and norm to the way juvenile justice is dealt with internationally. And this is regards to everything from diversion and criminal justice, which I'll talk about today, but also witness protection, education, really every aspect that the juvenile has in society. But as I said, this isn't really where I want to bring you, because that would make my audience look like this. And so really what I want to get to, and what all of these things actually say, is pretty simple. And it's that children are not tiny adults, and they don't need to be treated like tiny adults, legally and socially speaking. Juvenile justice matters, and diversion matters, because around the world there's approximately 1 million juveniles in incarceration. And it's generally accepted that the majority of the 1 million juveniles don't need to be there. They're there for any number of reasons. It could be a small legal infraction, petty theft, status crimes related to poverty or homelessness. Whatever the case may be, many countries around the world do juvenile justice wrong. Broadly speaking, and this should not be a surprise to anybody, children are different than adults. And they're different for any number of reasons. They're obviously still in a developmental stage, mentally, emotionally, hormonally, they are just simply not adults. There's a reason we have an age of majority and an age of minority. We use the term minority because they haven't completely developed into a full functioning adult. So what does this mean for the criminal justice system? It means that we treat their culpability, or the way that we can blame them for a crime that they committed, differently. Because they don't have the complete decision-making mechanisms that a full-fledged adult has, because they're still trying to figure those things out. So what that also means is that the usefulness of a punishment for an adult isn't going to have the same effect on a minor. I mean, you can just see, the idea of a censure is pretty well understood by an adult community, but can you think of censuring a 12-year-old because he stole something? You first have to even explain what a censure was. So the idea that we can apply the punishment that we do to adults to children is fallacious at best. The idea is that we need to actually work in a way that helps them develop as people, helps them re-socialize, and helps them rehabilitate. The other big thing, especially when looking at crime, is juvenile crime. The majority of it is committed in groups, or also just peer pressure. You look at statistics, and this is true of Kosovo, this is true of the United States, it's true of Britain. The statistics say that usually it's 60 to 80%, depending on what year and what country you're looking at, commit crime in a group. So there's a peer pressure aspect there that doesn't say that this child is inherently bad or predisposed to commit crimes, but merely that the forces in his life at that period of time are not positive. So what society needs to aim to do within juvenile justice is make more positive forces in that child's life. So as I was saying, that this is basically codified in all those treaties and conventions that I mentioned, the Convention on the Rights of the Child, or as I'll just refer to here on out, the CRC, all codify these things. And the focus is a main dichotomy. You can either have retribution or you can have rehabilitation. Retribution is jail, it's fines. If you committed a crime, you're going to lose some of your freedom now. Rehabilitation says that we understand that children are in a different developmental place in their life and therefore need to be treated differently. So rehabilitation will focus on resocialization. It will not send children to jail. It will not necessarily just fine them. It will focus on their developmental stage in life and educating them on how to become a better part of our societies. But around the world, we do not see this happening. As I said, approximately 1 million children are incarcerated. That number is very much a educated guess by those that study this, because most countries don't even have the paperwork to know who is in their prisons, which is one of the many problems that face juveniles in prison around the world today. A child in prison has greatly increased chances of abuse, both sexual, mental, and physical, as most of them are put in jails with adults. There's not this idea that has been implemented in Kosovo and much of Western Europe where you separate children and adults in prison. Most places just put them in the same room together. It increases chances for medical problems, emotional problems. It increases the likelihood of recommitting or recidivizing a crime. Because when you put a kid who's 14 in a jail full of a bunch of hardened criminals, that becomes criminal university. It doesn't become a chance for that child to learn, to re-socialize, and to make better choices for himself.
What part of the convention does the United States object to?
Well, this happened in the 80s, and at that point in time, we were still, had children on death row, which happened until, I believe, 2005. Because state by state, we have different levels of culpability for age. The youngest in the United States is 7. The CRC hopes it's closer to 12 or 14. We also incarcerate all hell a lot in the United States, and that's definitely antithetical to the CRC. So while the discussion hasn't come up since the first Bush was in office, I believe that's where a lot of the problems were. And now also, of course, there was a vote recently on the disabled UN treaty to basically take the Americans with Disabilities Act and turn it into an international law. The Republican Party has taken particular umbrage with the UN and whether or not it's going to start controlling the US federal government, which isn't true because no UN convention is binding, but that's also a common thread in the US political discussion. But back to the discussion of why there's all these problems for children in the criminal justice system today, really it comes from 2 places. One, there's no process. No one just takes the time to create a process within the legal system to get a kid from the point of committing a crime to getting him out of prison or rehabilitation. And secondly, there's a lack of training to tell people that kids are in fact different. The easy thing to do for a prosecutor is to just treat them like an adult because that's what they know, put them in jail, they'll figure it out later, and then they'll be released. And it's that simplicity that causes a lot of these problems. But the problem with retributive punishments is that they decrease the chance for resocialization, obviously because they're in jail, not in society. It increases the chance for recidivism, and it also, as I said, increases the harm of the child. What does work is rehabilitation, resocialization, and it should be pointed out that this isn't being soft on crime, which I think is the obvious critique to make about what I'm talking about today. It's to acknowledge that children are at a different developmental place, and therefore being hard on them and putting them in prison is actually just a useless, except for your truly bad crime. We're talking about murder, we're talking about possibly rape. Things like that do need to be sent to prison or into a harsher punishment. But for the majority of crimes that children commit, those are not the crimes. The majority of crimes are theft, they're fighting, they're driving infringements, things like that, things that don't need prison. So with that in mind, let's look to the current state of the juvenile justice system in Kosovo. The age of responsibility for a minor in Kosovo right now is between the ages of 14 and 18 years old. If you're under 14, you can't be held criminally responsible. If you're above 18, you're going to be tried as an adult. Simple enough. So a kid is going to put on one of these masks and he's going to go commit a crime. He, of course, did not plan his crime very well, and he's going to be arrested. When that guy is arrested by the Kosovo police, there have been trainings for the Kosovo police to have them better understand that you treat a child that you've arrested differently than you treat an adult. This has had, from what I hear, varied success depending on what region you look at. Every police station in the country now has a child-friendly room for interrogation and holding. This is a huge step forward. Most places that, as I said, everyone gets jailed in the same room with the adults. Kosovo has proactively decided they are not going to follow that trend. However, again, the child-specific rooms are used to varying degrees of success. If you talk to prosecutors, they tell you that the police need more training, that you need police-specific training, or juvenile-specific police to deal with these crimes, to know how to interrogate them in a child-friendly way, because obviously you're going to have a very different conversation with a child who has a different respect for your authority as a cop than you would with a 30-year-old felon, right? Like, that's just an easy assumption to make. They also say that the police need more sensibility, and they need a clearer process for the police. But on the whole, the police are making strides as it stands right now. So after the police make that arrest, they're going to give the case to the prosecutor. The prosecutor, I'd say, them and the probation office have made the most obvious strides in the right direction. At this point, if they believe it's important, they'll ask the probation service to do what's called a social survey. The social survey will look into the child's background, his family situation, his education situation, socioeconomic situation, and then give that to the prosecutor so the prosecutor has a better sense of where this child is coming from. Because again, when you're dealing with children in conflict with the law, the big issue isn't the crime that they committed, but rather the cause of why they're committing that crime. And if you can fix that cause, then again, putting them in jail does not make any sense. There have been huge trainings put on by UNICEF and the Kosovo Judicial Institute that have just finished training the trainers of trainers, which is a huge step in the right direction, that now you have people that are committed professionally in the prosecution service to deal with juvenile justice. This has not existed before, ever in Kosovo, and so this should be lauded. The other big thing is that in every region now, there's at least one juvenile justice prosecutor specifically focusing on juvenile justice. Again, this has never been done before. And where there isn't a juvenile justice prosecutor that's been trained for juvenile justice specifically, there's one specifically assigned that in the future is set to be trained. So these are the things that you want to see when developing a juvenile justice system. So from the prosecutor, you're going to go to the courthouse if they decide to press charges. This year, starting with the judiciary and the new law on the courts, there's a juvenile justice department in every court in Kosovo. Again, this has not existed before. This is, again, back to the idea of training the prosecutors, increasing specialization within juvenile justice within Kosovo. One of the biggest problems you'll hear from juvenile justice practitioners in Kosovo is that they would train somebody, and before the training was even over, they'd be moved to a different department. They'd be put on a civil law docket, or they'd put on an adult criminal law docket, creating a lack of continuity and a lack of specialization. But however, creating this department, creating a specific institution within the courts, helps fight against this. It creates a place for these people to make a career focusing on juvenile justice. Each court now has also one juvenile justice specific judge, which again goes to increase specialization. So at the court, there's obviously two things that can happen. There's an adjudgment towards being innocent, and that kid can leave, and that's it. The end of the process there, not terribly interesting for us. Or the kid can be found guilty and he can be incarcerated. The incarceration in Kosovo is actually fantastically good. It is a leader in the Balkans for what its standards are and what it's been able to accomplish. Countries like Serbia, Albania, and Montenegro look to Kosovo on how to implement juvenile justice and juvenile incarceration. Why? Lipjan. There's one juvenile justice facility in Kosovo, and it's the Lipjan facility. And really, for the most part, Kosovo does not incarcerate a lot of kids. Any given year, it's between 30 and 40. The sentences are no longer than 4 years, but they average more between 6 and 12 months. Men and boys are separated in the prison. That's a huge success. You don't see that in most countries that are recently post-conflict and still developing their legal system. One minor shortcoming is that women and girls are not separated. I broadly think it's because of resources, and girls, make up less than 2% of juvenile criminal offenses in the country. So it would obviously be a lot of infrastructure for a very small number of incarcerated girls. The other thing that Lipjan does for the juvenile facility is that they have education and rehab options, which is also huge. It notes that some crimes you have to incarcerate a juvenile, but it also notes that while they're there, you need to make sure you don't take away their humanness, You don't take away their ability to socialize. You don't take away their ability to educate themselves, which is wonderful. And then this fried egg or watchful eye is the probation service. After a juvenile is incarcerated in Kosovo, ideally the probation service will watch over that child for 12 months, making sure they go back to school, making sure they don't reoffend, making sure that they're doing whatever training or agreements they had upon release from prison. That also is quite progressive, not only for the Balkans, but generally speaking. So that is the process as it stands right now, looking at all those parts. But as far as diversion goes, so diversion, and that's the focus of my research, in a nutshell, is when you don't want to send a kid to court, you don't want to prosecute, you divert him into an alternative sentence. Alternative sentences take many different forms: community work service, mediation, reconciliation. They're those rehabilitation, resocialization things that you want to see within a prosecution, within a juvenile justice system. The big deal is that it creates ownership over their actions as opposed to just punishing them for their actions. And so in Kosovo, the crime and the police are the same in this regard. Where it gets different is the prosecutor. Now the prosecutor has this thing called prosecutorial discretion. It means that he gets to make the final decision of whether or not he or she is going to prosecute the offender. If the crime is too small or the evidence is too thin, they're going to not press charges even though the police might want them to. So within that umbrella of prosecutorial discretion, the prosecution is given an option. They can either charge the kid and they can go to court, as we saw in the previous slide, or they can go through diversion, which is dealt with by the probation service. And we'll talk about the specifics of that. The judge also has the power to send the case into diversion, but for the most part, from what I talked to, at most 10–15% of diversions actually come from judges. The lion's share are coming from the prosecution at this point in time, which I think is partially a training and education issue, or perhaps just that the prosecution is sending enough cases to diversion that the judges don't really worry about it. I think it's a combination of the two. I try to use pictures as much as possible because words are boring on PowerPoints, but I didn't know what icon to use for statutes, and so I just gave you the statute itself. Kosovo has very strict statutory standards for diversion. You have to be a minor. You have to be between the ages of 14 and 18 when the crime is committed. The offense, as far as this punishment is concerned, statutorily needs to be a fine, needs to give you less than 3 years incarceration or less than 5 years of incarceration if you commit the crime negligibly, meaning you don't really put a lot of thought and time into committing the crime. The caveat being that if you kill anyone, no matter what the crime, you don't get to go to diversion. You're gonna go to jail. So that's pretty straightforward. The second half of that is that there's statutory requirements on the minor as well, and that's the part two. First is that the minor has to accept responsibility. It's obvious enough. If a kid says, I didn't commit the crime, then trying to rehabilitate them doesn't make a lot of sense because there's dissonance there between the system and where the juvenile thinks he is within the system. The big thing that I think needs to be changed, and this could be a translation issue, is that under the first point, where acceptance of responsibility, is that to be in line with the CRC and general juvenile law principles, the word voluntary has to be in there. The fact that it's not in there is actually detrimental because easily the prosecution could push them in a particular way, and that's not so good. I think the same is true of the second point. You want the child to be voluntarily ready to accept responsibility as well as to make peace with the victim. And then, of course, consent of the minor is very important. So once you have all of that, here are, something happened when I sent you this. There should be no percentage signs. I don't know why there's percentage signs. Those are just hard numbers, not percents. So this is what we have as of right now for the numbers that are out. We see an increase in the use of diversion. The number on the left in this one here is a number of social surveys taken, which is less than the number of prosecutions, but I've not gotten hard prosecution statistics yet, so this is as good as I have right now. But the important thing is that here there is an increase of the use of diversion. As far as the regions are concerned, Geelong and Prizren stand out as the exceptional regions in regards to the use of diversion, and it's namely on account of the prosecutors that are there. They've delved wholeheartedly into the idea of prosecution and use it completely. Mitrovica completely rejects the idea of diversion, unfortunately, for any number of reasons, all which I think are kind of BS. I think that the prosecutors don't buy into the idea because either it's too soft. They say that they don't have enough people, but to deal with a diversion case as opposed to taking a case to trial, the diversion case takes less manpower and time. So the excuse is crap as far as I'm concerned. But they're the only one, so that's actually a good thing there. There are 8 types of diversion in Kosovo, from reconciliation to restitution, school attendance, employment and training, community work service hours, traffic school, and psychological counseling. Of these, reconciliation and community work are the 2 most commonly used, which I have here. No percentage signs this time, that's handy. However, there's a lack in implementation of, if you talk to the not prosecutors, they'll tell you that it's a lack of creativity on the prosecution side to use some of these other options. If you talk to the prosecution, it's a lack of resources and funding. I'm sure it's a combination somewhere in the middle of the 2. To note, we'll go to, what's kind of interesting to me though, and I think notes perhaps the lack of creativity or the mix of funding, is if you look at traffic school, there was a big jump in 2010, and that was on account of a grant that they received, making it more applicable. And it's actually the only year where traffic school was used as a diversion more often than someone would have been prosecuted for a traffic crime. Meaning fewer people committed traffic-related offenses in 2010 than were actually given diversion. So clearly money is an issue, but maybe too much money might also be a problem. But if you look to, I don't know why there's exclamation points either. This is an exciting lecture, I suppose. These are the top 6 crimes over the past 4 years in Kosovo. The 3 in green are ones that are open for diversion based on the statute. The ones in yellow are not because the punishment is too large. These top 6 crimes are about 2/3 of all juvenile crime committed in Kosovo, of which 3 are divertible, which is a pretty good number. Of those, 2 of them, theft and illegal woodcutting, open themselves up for restitution or paying back to the victim. However, during this period of time, there were 1,233 theft and woodcutting crimes in Kosovo committed by juveniles, but only 96 times was restitution used in all of the crime committed in Kosovo. That divergence and dissonance there shouldn't exist. And I think that goes to say that there's still some time and some work that needs to be done in Kosovo. Oops. As far as the successes are concerned, I think they're actually quite impressive. The new Juvenile Justice Code from 2010 is up to snuff, more or less. There could be cross-referencing and some changes, but for the most part, all the things you want are there. As I said, males and boys are separated at Lipion, education, 12 months of supervision, and there's better increasing systemic training of prosecutors, judges, police, and probation. We see an increase in the use of diversion. All 8 diversion options are being used. They're not being used enough, I think, but compared to where we were at in 2007, it's a huge success. And Kosovo has and I don't know if it's a statistical thing, and the information isn't being collected completely, but Kosovo has a very low recidivism rate, right? The fact that children would recommit crimes. On average, it's about 20% a year, which in the US, you could see it as low as 60% of kids recommitting crimes. So depending on what town or state you're in. So that's very successful in all those regards. As far as the room for improvement is going, one of the things that has been most notable to me is the defense has been completely left out of the process. I'm told that the Chamber of Advocates has training for defense attorneys. It is not clear to me, however, how good that training is or how thorough. The prosecution is getting great training, the judges are getting great training, the state is doing great training. But I think that if we're going to have this idea that each side is represented by 2 equally powerful and important sides, as law and order would have us believe, that we need to train the defense better. Otherwise, it's a massive human rights issue. If you were training the prosecution to be really good at something and the defense not to be good at the same thing, it offsets the power dynamic completely, and it doesn't give those children that do have to go to trial the defense that they deserve. I think there needs to be more statutory clarity and profit referencing within the law. Kosovo just passed a new criminal code last year, which could easily be cross-referenced with the Juvenile Justice Code. And as well, internally within the Juvenile Justice Code, it would be helpful if it was cross-referenced for ease of use. Separating girls from women at Lithion, again, might not ever be a problem, as not a lot of women are incarcerated, or girls are incarcerated in Kosovo, but they should have the capacity if it did arise. And I also think that the age of responsibility for diversion should be lowered to 12. I don't think their ability to be prosecuted should be lowered to 12. But if a kid is going to go out and commit theft or commit a petty crime of some kind, I think it's better that we jump on it earlier to make sure that they don't recommit crimes later on when they're 14, 15, 16, or an adult. That's not popular. I think that's my Americanness coming through. I mean, we'll prosecute a fetus, basically, in the United States. So I definitely, from my perspective, have an acceptance to a lower standard than what a lot of Western Europe would consider an age for culpability. As far as diversion is concerned, the article that has all of the types of diversion that you can use needs a catch-all. It's explicit. These are 8 things, and you can't use anything else. That doesn't give diversion in Kosovo the chance to develop organically or incorporate parts of their culture that would fit in that area. So I think a sentence like, or other restorative justice processes as deemed fit by the prosecutor would fix that problem. It gives the prosecution service in Kosovo in general the room to play with different ideas to see what works. And I think that kind of fluidity and flexibility is important in the statute. One of the problems with diversion, if it gets too popular, this is if the pendulum swings the other way, is that prosecutors will just start sending everybody to diversion. Whether or not they have enough energy or evidence to put together a complete case, they'll just put them to diversion because it's easier. Diversion isn't really harmful to the child per se. And so with that in mind, I think that there needs to be a statutory standard that says that to send it for a prosecutor to be able to choose diversion, the prosecutor also has to believe that he has a fairly reasonable chance to take the case to trial, because currently that standard does not exist. If you don't have a standard to take the case to trial before you send it into diversion, I think diversion can be overused in cases that otherwise would just be thrown out. And so I think that procedural protection needs to be there. As I said, you want to incorporate voluntary into the standards of the child's actions getting involved. There needs to be increased capacity for community work service in Kosovo. As of right now, the list is very small of what children can pick from. They're mainly state institutions like hospitals and libraries. But it's not enough. I think public-private partnerships, working with different NGOs, would be a great start. As well, there's a little bit of a socialist hangover, I noticed, both working in Armenia and here, that the idea of free labor is not very popular for a lot of understandably historical reasons. And so within that idea, prosecutors that I've talked to don't want to give community work service because they believe that work should be paid for. But I think, and then we go back to the idea that restitution isn't being used because of a socioeconomic issue. I think if prosecutors were to combine the two to say, you can either do community work service for free or we're going to give you restitution, gets over the hurdle of it being for free, because in the alternative they would have to pay something. So in fact, they are working to not pay something, as well as it would increase probably the use of restitution in Kosovo, both which I think are good things. As I said, restitution and traffic school don't reflect need. And I also think there should be increased juvenile participation within the process. After all, it's called juvenile justice for a reason. And I think I'm out of time where that is. So I can either, I'll take a census. I can either talk about the youth court peer-to-peer stuff briefly and then go to questions, or I can just go directly into questions. Okay. One person. That's the majority, right? Okay, so on the idea of increased juvenile participation, and this has been an idea around in the US for quite some time. Recently, the Council of Europe in 2010 released a study called Children-Friendly Justice, and within it they did a survey of 25 European, or Council of Europe countries, including Serbia and Bosnia. The Serbia surveys did not include Kosovo, but Serbia was actually the biggest respondent to the study, oddly enough. They basically said in all countries, no matter if it was Western Europe, Eastern Europe, post-communist, it didn't matter, and they only surveyed children who had been in conflict with the law, is that the kids felt like they weren't a part of the process. They just felt like they were floating along as adults made all the decisions. And it made them feel as if the whole process was really moot as far as they were concerned, even though the process was to resolve an issue in their personal lives. While not based on this study, certainly to combat this idea is that there's over 1,400 youth courts within the United States today. And what they are is they are basically sentencing hearings where the judges making the binding decisions, the prosecutors, the defense attorneys, the clerks are all under 18, which kind of sounds crazy. But they're statistically very, very successful. Again, you're using these for crimes that are not huge. You're not going to use this for a rape crime or a murder crime, but certainly for many of the divertible crimes that Kosovo would divert anyway, it's very applicable. The idea is, and as I said before, kids commit crimes in groups because they have a group with a negative idea. This is the idea of flipping that narrative and using positive peer pressure to rehabilitate the child. Because instead of being a room full of adults, your judges look like this. They look like you, or maybe a few years older than you. And so that has actually been shown to decrease recidivism amongst people that go through the youth court process within the United States. As I said, they hold the same kind of procedural protections of any local constitution. The process looks very similar to what a court would look like, but the players are different. The successes include lower recidivism. It decreases cost. Youth courts are insanely cheap to run. With like 2 permanent staff, you can run 400, 500 diversions a year with an army of juvenile volunteers. It increases civic involvement, and I think this is the most important part for countries that are developing their rule of law system and their legal culture, is that, like cigarettes, you gotta get kids young, right? We need to make sure that kids at a young age feel involved within the civic process and the legal process. So you see interviews with kids that have gone through these processes in the States. It increases their civic involvement in other organizations. It increases their willingness to believe in the legal system itself. And I think those are the kind of things that Kosovo needs. If my students are any indication of the juvenile thoughts about, or the young thoughts about Kosovo's legal system, is that it's a corrupt joke. However, I think if you make the juveniles a stakeholder within the juvenile justice system, that begins to change. Because then they begin to become those actors. They get to act in a way that they foresee their government acting. And I think it's important that we start that young, and I think this is a great way to be able to do it. I think the idea is that when kids are a part of justice, they're going to believe in justice. And so a program like this allows that to happen, and it allows to have it at a very cheap rate, and it happens, and it happens in a very successful way. So as far as Kosovo is concerned, I think it's the right time for this. Kosovo has made huge strides as far as their juvenile justice is concerned, and they have a lot of the procedure in place. They're doing all the right things, and so I don't think like a program like this is premature. They're completely flexible because you can create them to what they're going to be locally. They reflect local law and local heritage. And so it's not as if there's like a cut and paste from the United States to Kosovo, which I feel there's a fatigue of cutting and pasting laws in Kosovo, so let's try to avoid that. Like I said, they're inexpensive, they increase civic involvement, uses positive peer pressure and lowers recidivism. Getting them started also would not be terribly difficult. The legislation is very easy. You make one change to the Juvenile Justice Code as it stands right now, and then you, the one that I mentioned, the catch-all provision, in what could be used as diversion. Or my lawyer mind says that since all the punishments you give in a youth court situation are the same as the ones that are already allowed, you could probably weasel your way around it, but you might as well allow the statute to do it full on so there's no conflicts. And then you need to get the prosecution and judges on board so that they are diverting juveniles to the youth court system. And then finally, you need to come up with an administration. I think in Kosovo, an ideal place is the law faculty at the University of Pristina. You could run it as a clinic where you have young, aspiring lawyers helping train these juveniles to be more productive parts of the legal system. And so that way it's a benefit to the University of Pristina, it's a benefit to Kosovo society generally, and a benefit to the diversion system here.
What's the criteria for a juvenile serving on a youth court?
Within my experience is that a juvenile will take classes, essentially bar classes, pertaining to the applicable laws and procedures that a youth court deals with. And then they have to take a bar exam, where just like in any other bar exam, you have to pass with a certain score. And then you're in at that point, you have to attend a certain number of meetings. You start off at the clerk or bailiff level, and then you become an assistant attorney, and then a lead attorney, and then an assistant judge, and then a presiding judge. A process that I personally went through between the ages of 12 and 18, which is why I'm such a big advocate of these things, because I think from a personal perspective, they're phenomenally good in a number of different ways.
Before you both go on, since you've got some experience with that process, that system, you spent 4 years in college, 3 years in law school to stand at the bar as a professional lawyer. How is that similar or different in this? I mean, it seems shocking to me that, you know, a 28-year-old who's gone through college and law school will be a lawyer, and a 12-year-old who's gone through I don't know what is the lawyer for. Could you kind of enlighten me a little more about the process, the education process, the training, whatever? How are they qualified to do those things?
The big difference now for me is now with my law degree is that I get to go back to the youth court I was a part of and be a legal advisor for the juveniles that are now there. But besides that, I suppose not much has changed in that regard. The qualifications come from any number of reasons. One is that when you convert a child through youth court, they've agreed to go through this process. They understand what the process is going to look like. They are agreed that instead of having an adult judge, they're going to have peer judges and peer prosecutors. I think that's a huge part of it, is that the consent aspect of it. As far as their qualifications to doing those things, the way that you check for these is that you always have an adult lawyer sitting in the back in case, so I've never seen this happen in the hundreds of cases I've done, but in case something does go wrong or there is a legal question, it can be dealt with. These, and to be clear, these are sentencing hearings. These are not trials. And so, the kid is, in the Anchorage Youth Court context, the kid that's being sentenced has admitted no contest, which doesn't mean quite guilty, it doesn't mean quite innocent. It says, I'm just not going to deal with the charges. And so you're jumping to this, and then from there, there's a sentencing scheme that you can work from based on what their crime was, where it stands in the misdemeanor scale, and then that's going to be dependent on how many work service hours they're given, how long their essays are. If within the work history they're given it notes that they have a problem with authority or a problem with their parents, you can do parent mediation. And so these things are all scripted. The judges get work from a script, except for when it comes to the sentencing itself, they work by a sentencing guideline. And so all these procedural protections keep this process going for people without a completely, a K through JD education. And actually, at this point, I can be done talking. I was going to put up a couple of websites in case there's interest in the youth court thing. Youth Courts International is the organization I helped co-found, and we've been working in South Korea, Armenia, a little bit in Kosovo. We just got started last year. More thoroughly is youthcourt.net, which is the American National Organization. They've got all the research, all the studies, all the enabling legislation from the 50 states that they exist in. And I would highly recommend you check out their website. You can check out ours too. It's still a work in progress, but you'll get more from the other one. But at that point, I'm done, and thank you very much for coming.
15 minutes left for questions and discussion.
So you, in the youth courts, you also mentioned one of the benefits is the minor is not feeling like they're being just held along to decisions by adults. But instead now they're just being held by decisions by their peers. But how do they feel like they're involved in the process? How does that release that?
Well, when you're not, the inherent problem is that when you're an adult talking to a child, you're talking down to the child, both physically and usually rhetorically as well, you're talking down to the child. When the courtroom is filled with people in your same social situation, you're all in high school, middle school, the discussion is just different. There's a different perspective. They are at the same developmental, hormonal model state that the defendant is, and that's something that a 60-year-old judge just simply can't understand or be able to relate to.
So if the offender is 12, are people in the court are 12, or are they whoever happens to be in the youth court? I mean,
The big thing is that you make sure that no one is from the same school working. You don't want anyone working to know the defendant. Besides that, usually the way it works is your bailiff and defendant are 12, 13, 14. They're new members. Your lawyers are somewhere between 14 and 18, and then your judges are 16 to 18. So there's a process as you work within the organization that as you get older, get more experience, you'll be given more responsibility. Follow.
How do you think this thing could be not a problem in Kosovo? Because everyone knows everybody here, especially if you're in Pristina, you kind of know everybody. So you wouldn't really want your older cousin sentencing you to doing something. I mean, A, it would make it all unfair, and B, it would just be really awkward and uncomfortable for both parties.
My answer to that is that youth courts work everywhere from Washington, D.C., which is a huge metropolitan area, to extremely small towns of 5,000 people where there's maybe one high school and they still make it work. And so, like Palmer, Alaska is a great example. They have a very successful youth court program. The town is maybe 10,000 people. I mean, Kosovo is obviously much larger than that. And I think that everything's close enough also that if, say, someone was committed a crime in Farazai, they could come to the Pristina Youth Court, or if someone in Jalan could go to PIS. You know, there's workarounds, I think. I don't think small communities don't get youth courts.
Well, actually, I had a small question about your research. I don't know whether you mentioned it before, but you told us that many countries fail in juvenile justice, or they do something wrong. In a particular case of Kosovo, I was wondering, are you using a specific model or a success story or a country, or how do you compare, or?
To base, like the standard.
Yeah.
I mean, it's that stuff that I named. I mean, the Convention on the Rights of the Child, the Beijing Rules, Tokyo Rules, Vienna Guidelines,
Okay.
all these international instruments that have more or less created the standard that you expect internationally from a juvenile justice system.
Yeah, okay.
So I'm not looking at any particular country, because I don't think no one has a perfect model. I mean, Sweden, everyone who goes to jail in Sweden gets like a suite at the Ritz, but besides that, I don't know of any country.
Hi, at the beginning of your lecture, you mentioned that children are not tiny adults. I feel like this juvenile court system kind of, with the youth court thing, kind of goes into treating them like tiny adults, but then if they're not old enough to vote in the United States, how are they old enough to make decisions? I don't know. I feel like it's conflicting the two.
Well, I don't know if a statutory requirement on the age of voting necessarily takes away the abilities of a child's ability
Yeah,
to
but
make
how are
decisions.
they, if they're not old enough to make decisions like that, how can they make decisions for someone else? You know what I mean?
Well, I mean, we could look at Austria as an example, right? They've lowered their federal voting age to 16. It's now the lowest in Europe. And so I think that the idea that just because a voting age is at 18 is an arbitrary standard that we've set as a community in the same way that Austria has at 16. I don't think that 16-year-olds in Austria are much different than 16-year-olds in the United States or their ability to make a decision. And I also don't think, I think that Western society in general thinks that kids are dumber than they actually are. It does not give them the responsibility that they actually deserve. And so just because our society has decided to do that in some ways, I don't believe means that we shouldn't allow them the responsibility in other ways, which in this case would be the court system.
We've kind of followed through the actual child that's committed the crime, their whole process, and we followed through the prosecutor's process. I'm really interested to see about the parents and what's their role in this whole path that goes down after the crime's been committed.
That was one of the Council of Europe study I mentioned. That was one of the other big things that came out of it, was that the one thing that children said they wanted, besides to be listened to more, was to have a parent or trusted guardian there with them. For some, the parent will be there the whole time. For some, they won't be. It's a strictly case-by-case basis.
Will they have a say in what happens?
It depends on what the law says. The way the Kosovo law is written when it comes to diversion is that either the child can consent or the adult can consent on behalf of the child. Which I believe, and I'd have to go back and check this, is in conflict with the Convention on the Rights of the Child. I think it's supposed to come solely from the child, whether or not they're going to choose to do something legally. So that's the Kosovo example. I had not heard any stories about
prosecutor says they have to go, for example, to the center, or they have to do community work service, and the parents say, no, we don't think that's right, and who kind of gets the say?
I would depend on the prosecutor, I think. Because I'm sure some of them believe that the decision should be more centered. I would imagine this would be probably the case in Prism, because they seem to be one of the more progressive groups of prosecutors, is that they would say that it needs to be up to the kid. And this is why I think the term voluntary needs to be put in the statute, because we don't want either the prosecutor, the judge, or the parents twisting arms of the child in one way or the other. We want the child to be able to make these decisions and to be responsible themselves for the mistakes that they made. And so, but to answer your question, I think it would be, again, case by case, depending on the situation. And the chance that the prosecution and the parents don't get along is probably a good chance, as after all, the prosecutor is prosecuting their perfect angel child, right? And so that conflict is always going to exist.
When you were talking about the successes and failures here in Kosovo, you mentioned Mitrovica and its lack of use of diversion as one of the failures. Mitrovica court obviously is not a very well-functioning court right now. It's displaced.
Right.
It's a blue street. Were any of those put forth as reasons from the prosecutor there as to why it's not being used?
Surprisingly, no. And that comes from people that work in juvenile justice generally, as well as the folks there, is that there's a turnover issue, which might have to do somewhat with the moving of the courts. There is I don't think there's a training issue anymore after the recent changes have gone on. And the fact that it's been moved out of Mitrovica proper actually never came up so far as one of the reasons why they had some shortcomings.
Well, I mean, the places that we're at right now in Blue Street is almost non-functional because there's no space and it's very crowded and we don't have an ability to have hearings or trials. So when we say they would prefer to go to trial than to go through diversion, well, that trial will never happen. So I'm wondering what happens to the child at that point.
Well, that's one of the, actually, I forgot to mention this, that is one of the problems in Kosovo, and this is true in all areas of trial law in Kosovo, civil or criminal, is there's a massive backlog. Prizren, which is one of the success stories in juvenile justice, still has a backlog of 500 cases, of juvenile cases, right? That's huge. And that's one of the things that, you know, all those conventions talk about, is having a way for the procedure to be quicker for a child than it would be for an adult, because you want to be able to get it done with. And that is a problem that Kosovo struggles with, civilly, criminally. And I think the fact that they have recently created those juvenile justice departments within the courts is going to be a way to get at that. The fact that they're training judges to specifically deal with juvenile justice is also one of those. Because before it was, you'd have maybe 3 adult cases in the morning and then 1 juvenile one in the afternoon. And within that, you know, trend of treating everyone like an adult, the juvenile might not get some of the procedure and some of the safeguards that are guaranteed to them within the law. But now every court has 1 juvenile judge. And so that specialization should be able to help both the backlog and the specialization. But backlog is, of course, an endemic problem in Kosovo's legal system.
So the other question kind of follows from that is that when you put up your chart of some of the crimes that tend to be either candidates for diversion or not used, one of them was like illegal woodcutting, theft, and some of those. I know that those are crimes that are often done in co-perpetration with adults. And so there's always an issue of whether, you know, there's going to be a separation of the child from the adults, or they're going to actually try the adults in the minor offense court, or the minor court.
The statistics I've seen on kids committing crimes with adults is actually quite low. I think it's lower than 2%. In the years that it's something like 25 cases a year or something. So it's not a terribly endemic problem, but I would hope, and the statutes are not clear on this, that they would be treated as the law intends them to be, which is as a juvenile. And would probably, if I was the prosecutor in that case, would use it as a mitigating factor on the child's sentence because the child was working under the auspices of an authority figure.
No, well, what I meant was, in the court for minors, the juvenile justice court, the law allows the adults who also were perpetrators with them to be tried with them at the same time. So the juvenile is sitting next to the adult in the juvenile court being tried. How does that sort of work along the international standards?
well, as far as the international standard is concerned, that's wrong. It's interesting to me because I haven't actually heard anyone bring that up yet. But you're saying that the adults and the juveniles are just tried jointly?
Yeah.
Okay.
But in juvenile court,
Oh, so the adult is also the,
or if it's a traffic child, it happens.
okay. Clearly, I think the international law would say you need to sever those two cases. So that's good to know. Can you tell me which court you're thinking of?
I'll tell you that.
Okay, thank you. I saw another question.
Yeah, how's the appeal process compared to the adult court?
It's the same. The legal safeguards appear to be, at least in the law, all the same. That even within the diversion, you have the ability for appeal if you think that the diversion is incorrect or unjust or there is something wrong with the procedure. But for the most part, once a kid goes through diversion, he's out and you don't really see much at all afterwards.
Could you say something more about your organization? What it's doing, where it's active?
So when I graduated from law school last May, I had no employment prospects. I had not found out I was coming to Kosovo yet. And so, horrified, I decided to hire myself. And I and two of my friends who I worked with in Armenia started Youth Courts International. And initially, and where we're kind of at right now, is that after doing juvenile justice stuff at the UNODC and with the American Bar Association, no one had heard of youth courts. And with their broad success in the United States, I thought of all the bad music and movies America exports, this should probably get on that ship to other parts of the world. And so the idea was that we would create background flyers in multiple languages. I think we're at 7 languages now we operate in, thanks to volunteers that we have to help educate. We contact people that are looking to do these types of reforms in particular countries. Today I'll be talking with folks in Sierra Leone. Last week I was talking to people in England. England actually has a notoriously bad juvenile justice system, surprisingly enough, and but they're making changes. So I talk with them. I try to give them as much synthesized information as I can to help them be more persuasive to their governments and their organizations. We have model legislation to make that process easier as well. The hope is that we get to the point after we do our own capacity building of ourselves to actually develop a full youth court system from the curriculum of the youth court itself to actual implementation. That's probably a few years away, but that's where we are at right now. Any other questions?
I'd like to ask a question.
Okay.
Well, I'm inviting also to make some kind of forecast or your, let's say, estimation about the future implementation of this reform. Let's say in literature of, let's say, rule of law promotion, there is this dichotomy between rule adoption and rule internalization. So how do you think, specifically in the case of diversion, a culture of diversion will actually be rooted and people will trust to, let's say, resort to this, trust diversion and actually help this process get promoted in Kosovo, given, let's say, huge problems with, let's say, this almost proverbial culture of impunity in Kosovo and a huge backlog of cases and also the northern issue. How do you think that would?
There's a lot of questions there. I think obviously passing a law is fairly easy. Most of them have been pre-written by some organization. You can copy and paste a couple things and you have a law so long as other people vote on it. I think that the implementation and the culture behind that law, you're looking at a generational timeline. And I think that's completely acceptable. And I think that's what, and I'd say actually Kosovo seems to be moving quicker in regards to juvenile justice than that generational timeline would have you think. I think that there's been a structured approach to trainings and conscious revision, which has been shown in rule of law literature to be very successful. Ukraine during the Orange Revolution years, which have, may they rest in peace, but during the good years of progressive legal reform in Ukraine, the ABA took a group of judges from Kiev and Krakow, and they put them in a room and said, diversion's really great, you've never heard about it before, it didn't exist under the socialist system, but you should really try to implement it. And within that year, you saw a massive increase in the use of diversion in Kosovo. So I think it's about education, or excuse me, in Ukraine. Thank you for making that face. So when you see that, you know that a lot of that gap is just an educational gap. You get the information out there, you show them the resources that exist, and you begin to see the implementation. And I think especially in a place like Kosovo, where backlog is such an issue, diversion's an easy sell, both for the judges and the prosecution. They've got so many cases sitting on their docket that if you say, this is the way to take one case out of that docket, they're gonna thank you for it, right? Like, it's not as if they have a lot of free time on their hands, if nothing else, it's the opposite problem. So I think Kosovo is uniquely positioned in a lot of ways, both because of the juvenile programs are very easy to get international funding for. Juvenile and women's programs are the first rule of law projects to get funded, and then they deal with everything else. And so that has helped a lot. UNICEF's work here, KJI's work here, and everyone seems to be very much invested in this idea of reforming juvenile justice. I haven't, except for maybe Mitrovica, I have heard no pushback to the idea that juveniles should be treated differently, or that these punishments are too soft, or they don't work. The reaction seems to be wholly in the opposite direction. So I'm optimistic, personally, that the current trend continues. So that's it. Thank you, everyone, for coming.